My name's Joanne Caffrey and welcome back to Police Custody Basics. And this next case, acquittal, to tell you about is again involving police custody errors, but specifically I want to home in relation to the healthcare professional, the HCP. So in this scenario we have a lady from a road traffic collision, officers attend, the officers try and get a roadside specimen from her, but she's displaying anxious behaviours and she's self-harming in some respects as well in front of the officers. They're unable to get the breath from her at the scene, and so they arrest her on suspicion of driving whilst being over the prescribed limit and failure to provide. So she's brought to police custody. At police custody, again, she's demonstrating highly anxious behaviours and she's actively self-harming, to the point that the custody officer, so the custody sergeant, he grades her as a level 4 risk. So that's the highest risk from the 4 levels. So level 4 means, if you look at the College of Policing Authorised Professional Practice, a level 4 detainee must be reviewed by the HCP. So she needed to be seen by the HCP before the procedure, because you've got to then think about, is she fit to understand her rights, entitlements, the statutory warning of the procedure, but the HCP isn't brought. So the lady's taken through to the breathalyzer procedure, the intoxilyzer, and attempts are made to get the breath, but she's still actively self-harming in the intoxilyzer room as well, and the breath isn't obtained before the machine times out. Now, through the discussions with the 2 police officers and the detained person, the police officer accepts that she hasn't failed to provide without reasonable excuse, because she accepts it's due to the anxiety that she isn't being able to get the breath for long enough. So the officer on the drink drive forms, so the MGDDA, she actually records on there at A19 that she's requiring a lab specimen, yes. And she verbally says on the footage that she's going to formally ask for the blood procedure, and she was just going to go and get the HCP in order for them to go to the blood procedure. So far, you know, procedure-wise for that bit, you know, that's fine. She should have been seen by the HCP though before the procedure ever began. We don't have the footage for the next bits, but the intoxilyzer officer says in her statement that she went outside, spoke to the custody sergeant, who agreed that the blood procedure should be conducted. She then speaks to the HCP, who refused to attend the intoxilyzer room and refused to conduct or be a party of the blood procedure, and that the HCP advised that the lady had to be charged for fail to provide. And so the procedure continued in relation to just the custody. The female detainee was put into a cell, told that she'd failed to provide. There was obviously some disagreement between the detainee and the officers, because the detainee was constantly remonstrating the fact she'd been told that it was accepted that she hadn't been able to provide the breath and they were going to go to the bloods. She's then charged with failure to provide, and then on the morning of the court case, again the case starts with the legal argument. It's gone through all the case management meetings and everything up till now, and it now collapses on the morning of trial at the commencement of the trial. Because at the end of the day, you have to then look at what the HCP's role is in relation to the forensic part that they play in the drink drive procedures. Now, the intoxilyzer officer, so the police officer who did the intoxilyzer procedure, she is the procedural officer, and it's her decision whether or not, in her opinion, the detainee is progressing to the MGDDB, to the bloods. And that officer decided that that was happening. Now, all that needed to happen then was the MGDDB forms, the blood forms, are then commenced, and formal wording must be said to the detainee, and then a requirement is given to the HCP to examine the detainee, and it then moves on from there. Now, the HCP had no authority within the procedure to refuse to attend the procedure. Now, the referee as such is the custody sergeant. That custody sergeant should have known that the HCP cannot refuse to attend that procedure. Their role in the forensic role is to act and provide a service to the police officers, so the custody sergeant and PC. So the custody sergeant, they should have then had the knowledge and confidence to say to the HCP, no, you're being required to provide your forensic service for the MGDDB procedure, and that they have to go in and do this, and along with the procedure, they can't just refuse to take part in this, and they have no authority to tell the constable to charge the person for fit to provide. So that's just a top tip from that one. And again, you've got custody sergeants, you've got healthcare professionals, HCPs, you've got your detention officers, you've got your intoxilizer officers or your investigating officers, all working within the custody process. But ultimately, the custody sergeant, that custody officer, is liable and responsible to ensure that everything occurs correctly. They carry the can, they are responsible, and they have the liability to ensure that the procedures are conducted correctly. The HCP as a function, they have two functions, the HCP. One is the clinical role, which is the doctor-patient role, and that is between them and the patient and their medical body. But when the HCP is acting under the forensic role is to take part in various procedures such as fit to detain, fit to interview assessments, reviews because of the observation levels, the Road Traffic Act procedures. They conduct those procedures and the forensic roles on behalf of the custody process, the custody officer, and then they give their advice. They cannot refuse to conduct it, and as such the custody staff can seek either a second opinion or go to the likes of there'll always be a supervisor on duty for that area's HCPs. In the first instance, if there's any conflict with the HCP, the custody sergeant should be contacting the on-duty HCP manager in order to discuss this. And so that's just a quick topic that I wanted to cover. Again, another case, either, it's either a driver who should have been prosecuted but the case collapsed because of the errors of the process, or the driver was put through months of stress and trauma and expense with their defence to get to the day of the court case for a case which really should have been sifted out much earlier. And when we talk about backlogs and case backlogs for people, such points to prove and issues like that, they should be getting identified early doors and either corrected while they can be, or for case management, getting sorted. So thank you very much. My name's Joanne Caffrey, Expert Witness Services, anything in relation to police custody, and likewise the training around police custody. Thank you very much.